the data. And then a very key issue, data security measures. Data security measures are the biggest concern for a company, or in the eHealth scenario, for the eHealth service provider to go cloud. Why? Because the directive and also the laws that apply the directive in the member state have very stringent security measures, called, for example, minimum security measures. And if you don't comply with that, you will get fined. And even you will have to face criminal liability if you don't comply with minimum security measure. What does it mean? It means that the data controller has also to check whether the data processor, so the cloud computing service provider, has in place minimum security measures. Data subject rights. The patient, in this case, will have the right to know the amount of data that are processed, to correct them, and to also block the processing of the data, or to ask for erasure, deletion of the data. This means that the eHealth service provider needs to have an agreement with the cloud computing service provider to be able to receive that information. And if the patient asks, please delete my data or rectify, correct my data, then the cloud computer service provider has to do that. And finally, another key issue is the data transfer. So when you go cloud, you basically transfer your data from your organization to a third-party organization. And this third-party organization can be located in Europe, but can also be located outside the European Union, and possibly in a country that does not guarantee a minimum level of data protection. Therefore, you need to have the consent of the patient, meaning that when you collect patient data, you have to ask for the specific consent to transfer his data to a third country, to another to the cloud provider, actually. And if you don't want to have the consent, then you still need to have something in place. The directive talks about model clauses, for example, which is a contractual agreement. You have to take this extremely serious, because failure to comply with data protection laws may lead to administrative, civil, and also criminal sanctions. How you solve the problem? That's my last slide, which is the most important. Basically, we have to deal with the means, legal means that we have. We have the directive, sometimes it's not very clear. So we really need to have very detailed contract in place. That's the only way. And in a contract, what do you have to look at? You have to look that the scope of the processing are very clear. I'm talking, of course, about the contract between the eHealth service provider and the cloud provider. So the scopes of the processing must be there, and the cloud provider must agree to process the data only for that scopes. The cloud provider, on the other hand, needs to, or wants for sure, guarantees that the eHealth service provider collected the data in a fair way, like giving the information notice and asking for the consent of the patient. And finally, you want to have security measures in place, very detailed security measures, because you talk about sensitive data. So you want to have them specified in service level agreements or in specific annexes. And then, as I said before, if the patient wants to enforce his rights, you need to have a specific clause in the contract that says that the cloud provider will cooperate with you in order to tell the patient which kind of data are processed, which way are processed, and to modify them, rectify them, or delete them. And the other important thing is that you need to have, in my opinion, also developed within the ENISA group, it's better to have model clauses in place in order to transfer data than the consent, because actually the patient can also withdraw the consent. And if the patient withdraws the consent, then you need to have back the data from the cloud computing service provider, or you cannot transfer the data anymore. Whereas if you have model clauses in place, it's a permanent framework to send the data to the cloud provider and process them in a fair way, of course. Last but not least, if we are talking about, for example, NHS in England, they have of course, a huge power, or government, then you can sit at the table with the main cloud providers, for example, Google or Microsoft or Amazon, and you can even think about that if you have enough bargaining power, you can put penalty clauses if they breach data protection law. Or you can even put a termination clause that if they breach data protection law, you can actually unilaterally terminate the contract and move to another provider and have all the data back. So that was my presentation. For any kind of question, you can email me. Keep an eye on the results of the NISA project. You can also have more information on what I do on my personal website, and feel free to contact me afterwards to have clarification with a cup of coffee. Thank you very much.
Thank you very much, Paolo, for this cold shower. So we will pay attention to all these details. Now we will